Good afternoon and welcome to this webinar on occupational health issues and criminal enforcement. My name is Ben Pollard and I will be looking after the technical aspects of this webinar today. You will notice a chat box in the top right corner of your screen. Should you have any technical issues during this webinar, you can ask any questions and I will respond directly back to you. Please though, can I ask that you refrain from sending messages in the chat box unless they are to do with any issues you are having. I only say this as the chat box can get quite busy otherwise. Your speaker today is one of the IOSH Food and Drink Committee members, Chris Green. As well as being a member of IOSH and the Food and Drink Committee, Chris is a partner in the Regulatory Services Unit of Weightmans LLP Solicitors, where he specialises in health, safety and environmental prosecutions following fatal and catastrophic accidents in the workplace. I would like to thank him very much for coming today to deliver this session. Before I pass you over to Chris, just one final point is that you will notice a separate Q&A box in the bottom right corner of your screen below the chat box. If you have any questions for Chris during this session, please ask your questions into this box. At the end of Chris's presentation, we'll go through and answer any questions you have submitted, but obviously should we run out of time and be unable to tackle all of the questions, we'll try and provide written answers that will be emailed out after the webinar. I shall now pass you over to Chris and hope you all enjoy the session.
Good afternoon to you all. I hope you can hear me. Welcome to IOSH. I speak to you not from our office, which would look like the picture in the photograph, but from the IOSH HQ here in Leicester. It's a gloriously sunny day and I'm joined by Paul Fenner, who, like me, sits on the Food and Drink Sector Committee of IOSH. He's here to add any practitioner points while I do the legal bit, so to speak. So that's us. The reason why we thought this might be a topic of interest is because for about 20 years or so, I've been dealing with more accident cases, fatal and nasty injuries and the response to them and how it goes through the court. In about the last 6 or 9 months, I suddenly saw a host of cases coming through that were more to do with occupational health matters and manual handling in particular. I mentioned this to my colleagues on IOSH committee, the other part of the role rather than the day job, and they thought this was worthy of mention to the industry and to give you a few pointers as to how things will be viewed going forwards. So without further ado then, let's just have a quick skip back over the last few years about how HSE have been enforcing health and safety legislation. You will have gone to very many seminars, I'm sure, and heard their mantra being sensible risk management, and very consciously the focus from the health and safety executive over the years has been to target just your priority risks and your key activities. And there was an appreciation, particularly during the economic downturn, that you couldn't do everything. So being entirely candid, it's fair to say that occupational health issues probably weren't really on the radar. The emphasis over the past few years has been very much on practical steps and control measures rather than audit trails and useless paperwork and documents to prove those steps. HSE have been very, very clear on that, and things have come full circle, as we'll see in a moment. This has all coincided, of course, with the number of inspectors and the resources available to the health and safety executive being somewhat butchered in places. So, of course, fewer inspectors means fewer inspections, and the figures that were supposed to have been generated by the FFI visits, of course, were probably, in hindsight, never achievable. There aren't enough inspectors around to do that. But what all of that means is the focus under the Fee for Intervention initiative for costs to be paid now is wider, and you could envisage a situation where occupational health matters meant that you were paying £124 per hour for the HSE's intervention and their assistance to your business in dealing with these matters. Even though accidents and the nasty injuries have been still far more common, there have still been quite some suggestions over the years that the health ought to be put back into health and safety. This session is about 2016 and how the HSE are going to go about doing that. Far more ill health, occupational health type risks will be much more at the forefront of their agenda for these reasons. You may have seen that they've recently published a strategy, and the document Helping Great Britain Work Well 2016 is really a recognition on the HSE's part that they'd say they've done a pretty good job over the years. They've reduced the number of fatalities in general, the trend is down, and there's only so far they can go to improve it still further. They'd say the number of injuries again has been tackled and they think they've got a pretty good grip on it. They would say that's because of the way that they've enforced health and safety legislation and sent out a real deterrent message to industry. But they've now focused on how they can improve still further, hence this change in emphasis. And they're now saying that because industry generates the activities that create risks to ill health and occupational health matters, then it's really down to the duty holders to manage it better in a proportionate and a sensible way. So what they've done with accidents, the HSE are now looking to do with what you might have regarded historically as perhaps some of the more soft stuff. But I don't mean that in a disparaging way. If you actually look at why health and safety issues need to include occupational health, then you really only need to look at some of the statistics, particularly in the food and drink sector, but not exclusively. A lot of what we're saying today is based on our experiences from the food and drink sector, and as I say, Paul will answer any of those questions, but we hope that the principles will apply more widely to those outside of food and drink, potentially even outside of manufacturing. Do shout with any questions as we go along. We'll try and cover them at the end. So there it is. That's what 2016 looks like. First key point from the cases I've had over the last few months, it's not right to say that occupational health matters and ill health in the workplace are just a safety issue. We've seen that a multidisciplinary approach between your HR department, possibly your insurance officer or your risk manager, will really serve to put forward a programme of measures, firstly to prevent them from happening again and avoid you getting these claims, but actually in terms of what you do with these, in some instances, surprise claims that suddenly come across your doorstep all of a sudden. Now, HSE are quite clear in this, and we are now redressing the balance. It isn't just accidents. You now have to focus health issues alongside pure safety matters. Why then is the focus on manual handling operations and musculoskeletal disorders? Say before I go through that, there's a few acronyms in the slides for obvious reasons. I wouldn't have fitted them on the slides otherwise. Do type in if there's anything that the acronym doesn't clarify what we're talking about. So the statistics in food and drink, MSDs, as we know, represent probably the highest cause of injuries in the sector, and the same is true of ill health. Those are the classic injuries that are encountered by those in this sector, and it's usually the back strain, which can be really quite long in duration and can lead to my colleagues dealing with civil claims having to understand what the cause was and what the long-term symptoms are. It's a huge issue in this industry and beyond. So the purpose of the HSE's programme for 2016 is really as set out there. It's looking at the sort of activities that would generate those risks in order to generate a management plan to assess how they can be avoided and to reduce those risks so far as reasonably practicable. Now, we say right from the outset there is no obligation to eliminate those risks. It's simply a question of trying to reduce them and manage them as best you can. There's recognition from the HSE that that's pretty much all you can do. And you'll see the activities on that slide are probably of wider applicability than just food and drink. I had a look through the statistics because, as I say, I could remember probably one case of disease-related prosecutions in all the time I've been doing this job, and that was really borne out by the statistics. There's the obligation under the manual handling regulations there, reduce the risks as far as reasonably practicable. I've come across only one case prosecuted pretty much each year over about the last 5 or 6 years, and I found only 6 prosecutions from 2000. Fine in all of that time was only £4,500, so hardly the sort of deterrent effect that you would have expected for accident cases, and certainly not the sort of figures that we'll be looking at in due course under the new guidelines. What you are far more likely to have seen is that prohibition notices were served, but far more commonly improvement notices as well. And I can say anecdotally, I know of somebody who was served an improvement notice from the health and safety executive, who went to go and see them and said, if you'd known about our action plan and our assessment and our management of occupational health risks, you'd never have served a notice, would you? And the HSE agreed that that was the case, but then declined to actually withdraw the notice. So even now, there is a risk of an improvement notice being served, which again would stand on your record if you chose not to appeal it. If ever that happens, the HSE do need to go through quite a complicated process before they serve one, so it might be worth just having a second view about whether it's valid or not before you do the work required. You'll see from the next slide that we've tried to anticipate where all of this is going. And throughout 2016 and beyond, we think that HSE will attempt more commonly to apply the criminal enforcement route to ill health at work in a way they never have before. Can I flag up one practical point? And this has come from 3 or 4 of the cases that I've dealt with over the last few months. The inspectors are justifying a revisit because they'll go through their file in relation to a duty holder, usually the big companies for obvious reasons, and they will look at visits they might have made during the recession, where they might go and look at workplace transport or trips and slips or the usual suspects. But there's a throwaway comment at the end of the follow-up visit where they say, by the way, have a look at your manual handling. And of course, the reality is that because that wasn't a key issue at the time, and during the depths of the recession, what I'm finding is that an awful lot of companies perhaps didn't really do an awful lot at that time. The problem you've got now, 5 years on, of course, is that stands as a previous warning from the health and safety executive, flagging up the need to look through your procedures, and they are wanting a document trail to set out what you did in order to address their notification. And we're finding that companies didn't do an awful lot, and instantly the entry level for the health and safety executive starts higher, and therefore means companies are more exposed to some of the enforcement sanctions that we'll come on to in a moment. So you have been warned. It wasn't really on the agenda at all. Now it is, and all of that material that was dealt with at the time, it is now coming back perhaps to haunt you. MSDs. We never know the knowledge base of all people on the webinar, so apologies to those for whom this is fairly standard stuff. If not, I hope it's valuable for those who haven't perhaps made it on it over the years. But a few key points. The practical measures to address these and to bring about a real reduction in levels of harm aren't usually that onerous. So we saw a moment ago that this is still subject to a test of reasonable practicability. Reevaluate that and see whether the balance is still in favour of the mechanisms you had before, or now production has picked up, potentially you might be undertaking more activities than you thought. Review it all again, and it may be that's the first time you've had the chance to do that over the past few years. There is guidance that suggests that where it isn't possible to eliminate them or control them altogether, a lot can also be done by monitoring your employees, checking out any concerns that they have. Maybe there's the odd RIDDOR report form, maybe there's a few civil claims come through. The HSE's stance on that would be that they're probably more sympathetic to the company that's never actually had any harm reported, but once there is a bit of a history of employees saying they're being affected, then you're on notice and the duty on you to do something is that much higher. So there it is. We'll all be familiar with the hierarchy of measures. We're familiar with that with a lot of the specific six-pack in the regulations. Can we avoid the activity altogether? If not, can we at least assess a way of controlling it so far as reasonably practicable? I'm not sure I'm entirely with the HSE on the idea that you don't need a document, else how can you actually prove your reasonable practicability assessment and that it was correct and that you haven't missed something terribly obvious. But either way, let's just come up with something that's workable. It doesn't need to be gold-plated. Get it in place. The very fact that you've got a plan and a system should be dealt with favourably by the HSE. There's many who don't have even that in place. So there it goes. Doug can chip in with any of the, Paul can chip in with some of the practical issues that we have in terms of manual handling, but there is the process. Can I just flag up one point on that slide? The generic manual handling assessments on the face of it should go a long way to comply, if not be fully compliant. We don't need this to be gold-plated, and some of these standards are still evolving, even in the HSE's way of thinking. Now, your risk assessment needs to be suitable and sufficient, and it needs to have encompassed all types of manual handling, together with the individual factors mentioned in Reg 4.3, which we'll come on to in a moment. So it's part objective with reasonable steps, but it also has to factor in the particular characteristics of the individuals concerned. And the guidance is clear that perhaps self-evidently assessments that are made without having identified the risks, but only after you've seen people potentially subject to these risks and getting actual harm, they are far less likely to be suitable and sufficient if you're acting after the event. The MAC charts. You'll know with any form of criminal enforcement that the HSE's test is broadly how far short of the standards the law required the conditions they found in your business actually fell. And a lot of work has gone in over the years to methods of almost trying to define an industry norm, and they've come up with the manual handling assessment charts. It's quite specific. It's a tool produced by the HSE in order to identify some of the common generic risk factors, but it is quite thorough because it factors in duration of the lift or the stretch or the carrying, who's affected, where their hands are and what they're doing. So it started out with more high-risk manual handling. This, I think, is where the HSE are going, and they'd probably quite like to see this almost as a defined industry norm. If you're not aware of it, at least please factor in whether it's applicable in your business and whether you can do something about it. It's the flavour of the month. If you've complied with that, then you're far less likely to be receiving a notice or worse. This is what it's all about. It factors in the different types of assessment and comes up with the good old-fashioned score sheet with red, amber and green, and that'll help you to determine the level of risk pre and post any steps you take within your business. The MEC score sheet, again, going back to our earlier point, difficult to see if you don't have the score sheet how you can prove you correctly analyze the level of risk. But there it is. We break it down into low, medium, and right up to very high level of risk. So red, amber, green, and for those of us with particularly serious issues, then a purple as well. So that's where you are looking at individual circumstances, and it looks as if there needs to be some form of control measure put in place. It prompts a score, and that will tell you perhaps what's obvious, but stand and watch your employees. What are they doing? How long are they doing it for? How are they actually concluding the task? Is there any commonality there? Do they follow any rules? That's your starting point really for any risk assessment. Just check how they're doing it and ask them. And I hope your safety culture is sufficiently evolved that they might actually tell you the reality rather than tell you what they think you want to hear. There is a lot of material out there in relation to the MAC, and it's on the website. So the flowchart will guide you through what's involved in it, but it's a useful tool. There's the link at the bottom, and once you actually get into certain categories and certain scores, it almost prompts you to address some form of solution within your business. It isn't an actual requirement. HSE are clear on that on their website, but if you fail to adopt that or one of the similar scoring tools that are out there, then of course you've almost invited the HSE to ask you, well, had you considered it in the first place? Had you heard of it? And if you've decided it's not relevant for your business, on what grounds did you reach that view? I want to say something about the approved code of practice. A consultation went out at the tail end of last year, and the idea is that it's about to change. Not change hugely. The schedule, I think, was supposed to be end of April. It's not out there yet, but it's not far away. So again, factoring in what we were saying about industry norm, you need perhaps to have a look through L23 if you haven't recently, in light of it altering, use that as a pretext to adopt a review of your risk assessment process and see whether anything has changed. The duty to keep it up to date, and this is Regulation 4.2 at the bottom of that slide, you need to alter that with upscaling production, change of methods, new machinery, different individuals. But equally, there is an argument to suggest that you might want to review it and keep it up to date simply because the approved code of practice is altering. And we know that that isn't a legal requirement, but if you don't follow it, then you're inviting a problem that could easily perhaps have been addressed. That takes you into the broader picture of a general occupational health policy. As I say, sit down with HR and find out whether they are actually getting these complaints, and it should dovetail into a general workplace management and welfare type program. So I hope all of that shouldn't sound too draconian. As a lawyer, of course, I'm more interested with that hat on rather than as a sort of quasi-practitioner in the first of those three bullet points, the prevention of any occupational health risks in the first instance. Rehabilitation and health promotion might be arguably after the horse has bolted. But anyway, prevention, this is what the guidance tells you. You've got to monitor the sickness absence and go out and almost invite comments from your workers. Don't just wait until they've complained. Go out there and ask them whether this is an issue for them. You don't need to be as specific as saying, have you had any injuries, but you'll get a bit of a flavour for how they're doing it and whether you think there's any significant risks there. Paul is alongside me in case rehabilitation issues are of particular interest, and we'll take any questions there. But as I say, it is a hierarchy. Let's try to prevent them, or as far as we can reasonably prevent them, if we possibly can, before you end up having to go down that route. And then health promotion. I'm all for anything that will improve the profile and the repute of anything health and safety related in the workplace. But from a strictly legal perspective, I guess, let's just focus on prevention rather than cure. FFI then, just to put all of this back into context, we've certainly seen, and I could probably have a separate seminar or webinar just on anecdotes since that's been in place, but I've come across issues where FIFI, the fee for intervention, has been applied quite disparately in a quite inconsistent way. Please, in relation to all of these issues, don't be afraid to say to HSE, it's only more latterly that their focus has been on this sort of issue. So arguably, why should yours have been? I don't mean that in a blasé way, but you now know that it's treated as a higher risk and deserves a higher focus. So a lot of this should really be forward-looking rather than why perhaps you're not quite compliant in the first instance. So in relation to manual handling and occupational health issues, what sort of standards are the HSE adopting at the moment? General comment there, that's what you'd expect on any workplace inspection from the health and safety executive. We know that it's pretty much open season for any activities they want to look at, and of course on finding any material breach of health and safety law, including all things ill health, they can act accordingly and can charge you £124 per hour for the privilege. That should be fairly self-evident to those on the webinar. We know that the more severe of those sanctions is usually reserved for more accident cases or where the level of risk is really significant, but it wouldn't take an awful lot to turn what might have been a notice of contravention into a PACE interview under caution, potentially improvement notice, or potentially worse, and a case going through the courts. So a whole host of complaints all at the same time from the same place from a number of different employees, and you might find the HSE suddenly get very interested in this particular topic. Ditto if a number of riddles don't appear to be addressed and you haven't perhaps formulated a plan to address them. It wouldn't take much. So you will fare far better if between now and the time that the HSE arrive at your premises, if you can at least demonstrate that there is a plan in place and you're well ahead with trying to implement it. The inside track to those on this call in food and drink, but it may apply more widely under the HSE's new Work Well strategy, is that HSE have a proactive inspection program, and inspectors in the field have been told to go out and look for these things in the third quarter of 2016. But please don't think that necessarily means you're off the hook before then. If there are reports, whistleblowers or riddles in the meantime, of course the HSE can come round to your premises at any particular time, and they will of course view far more favourably anybody that started this process than somebody that really still hasn't perhaps actioned it in the way they would like. They've been given guidance as to how they define the level of risk and the risk gap. So this is in effect what you get at the end of a visit from the health and safety executive, and that all turns on how immediate the risk is and how serious the injury could become. The benchmark standard as far as what the HSE think industry would require, thankfully is still deemed to be a negligible risk of serious injury or health effect. The problem that you've got potentially is it's more what it says about how you manage safety than perhaps necessarily even the level of risk concerned on an ill health type matter. So where they're left with then is minor or significant breaches. Depending on the severity, you might be looking at an improvement notice as opposed to a notice of contravention. But where there is, quote, an immediate significant risk to safety or health, then there may be a prohibition notice attached to it as well. Imagine some of the lines and the clients that I act for suddenly with a prohibition notice relating to manual handling, and I can happily imagine the reaction that that would generate. So there it is. The inspectors go round and identify any MECs, matters of evident concern. They will determine from that just how high the level of risk is. For anybody in food and drink, I flag up that aspergens and carcinogens are the flavour of this year as well, so you have been warned. But going back to MSDs, it may well be you get a follow-up visit at your cost just in order to see how you're getting on with your ill health control measures and your plan. I heard a figure recently, and I think the percentage of material breaches in the food and drink sector were around about a third to about 40%. I can certainly say just anecdotally from some of the other industries that I act for that the figure is probably rather higher than that. So an open goal at the moment, if HSE come to visit, any steps at all to say that you're prioritising it will need to be made to stand you in good stead if ever they visit. And of course, this will be part of any inspection visit if they're coming to look at something else as well. MAC isn't the only tool out there. There's a whole host of guidance on this on the HSE's website, but you won't be going far wrong if you look to that in the first instance and adopt some of its principles. There's a little bit more in terms of the guidance and the process. I won't dwell on that, but we're happy to take any questions later. Some tips as to how you'd go through the risk assessment process as well as the MAC process. Can I flag one thing up at the end? And this comes from a particular case I had, deeply frustrating. This was a company that actually had really nailed this. It had super procedures in place. They were implemented, the risk assessments were all adequate, and the control measures were really good. They even went so far as to pay quite considerable sums of CapEx for some state-of-the-art lifting equipment. All seemed fine until that last bullet point there, and they hadn't actually proof that the employee who got injured and was complaining of an MSD had been shown how to use all of this brand new equipment. So it is quite an onerous obligation, and that's a self-contained requirement in its own right. Please don't fall foul of that simply because you haven't given the employees the relevant information. We've touched on that a moment ago in terms of the standards that the inspectors will be looking to judge. Benchmark standards and industry norm figures are out there. We can happily give you a level of compliance, but of course the fact that the rest of industry isn't complying is no excuse in your own business. That probably wouldn't wash as an argument against the HSE. So bringing all of this back to the current position, you'll know that from February new sentencing guidelines were imposed, and of course it may be that the absence of a procedure has been very long standing in a company. If a case went to court, then it's not beyond the realms of possibility that you may end up looking at these tables, which I have in pretty much every case that's gone on since February. There's now a stepped process whereby the prosecutor outlines the seriousness of the harm risked and the likelihood to bring you within one of the categories that you see on screen there. Now, again, anecdotally, but the case I have going before the court, the prosecutor has identified manual handling MSDs in harm category 4, level C. Now, that would potentially put you at the least serious end of the scale, but please bear in mind what we said earlier. It's not going to take an awful lot for HSE to go up within a category or even move up a category itself. And another lawyer that I spoke to in relation to where he would pitch the seriousness of harm said that's level B rather than level C. We may need some test cases to clarify this going forward. For now, it's all rather new. But you'll know that some of the factors that apply there might become relevant to which category it goes in. So look, for example, at 2.1. If there is an absence of a procedure, rather than that it's just not been trained out, logically, I guess you might say that's always going to expose a number of workers or members of the public to the risk of harm. Well, not members of the public, but if you without everybody's saying sound gone. If anybody can hear me, I think we have a technical problem with the sound. But if anybody could, oh, somebody said okay, back now. Thank you. It's back. Great. Apologies. I was just covering point 2.1 on that slide, and if you have a whole host of people complaining or bringing claims, then clearly the HSE might say you're higher up the categories. And what that means for sentencing purposes is you then go forward based on the size of your company. We'll have seen all of this, won't we? Go down, if you would, just to say medium culpability, so decent level of procedures, but maybe they missed one aspect of it or it wasn't followed through or implemented. Let's say it's a harm category even of 3. For those of us on the call with turnovers of over £50 million, go in front of your board and say the starting point might be £300,000 for what until just recently wasn't really thought of as a hugely significant risk. The landscape has changed rather. Worst case scenario, very high culpability. I hope nobody on the call would have that. That's almost sort of willful and flagrant ignoring of these procedures for the risk of cost. Even so, you're into a different category of fine at pretty much any one of those different levels. So there it is. There's the worked example. You could end up as a B3 medium with those figures without doing an awful lot, it has to be said. So nobody's demanding perfection just yet, but you have to have a bit of a plan as to when you think you're going to get some of these issues in place and at least assessed and have a look through MAC. Final word of warning before we conclude and take questions. Clearly, if you're a very large organisation, you're substantially more than £50 million, then all of those figures on the previous slide may be increased still further. It's all a voyage into the unknown. This is all new guidance, and we don't have an awful lot in the way of precedents just yet. So there it is. I've touched on that as we've been going through. This is an anecdotal case study, but what we didn't factor in that particular case was that as the business became more successful and production ramped back up after the downturn, not unreasonably, the assessments hadn't been updated. Didn't really matter that significantly, but it did allow people to ask the question. So that's what we have there. Specifics under 4.1b about what you've got to provide the employees with, and the allegation was that we couldn't prove that had happened, even though many of the employees knew what was required. There it is. The slides, I think, are available on the website, and the webinar will be available if anybody missed it. Failing all of that, please do send any questions in and we'll try to help them if it wants a more in-depth examination of some of these. I have Paul with me for more of the practical practitioner type questions as well, rather than just the legal. Run through there about the assessment of harm and how HSE approached it. We've just seen that in terms of the sentencing guidelines. and we conclude there with how all of this fits in together. It's a period of great change in health and safety law, new guidelines, new procedures in the courts, new strategies, new ACOPs. There's a lot really to take into account, but those are some of the headlines. We've done a bit of a whistle-stop tour through it now, and I hope that helps you to avoid any risks, avoid any injuries, and avoid the need to be having to consult somebody like me when, frankly, you'd be far better off the proactive
Hi
steps
Chris,
in
it's
your
Paul
business.
Fenner speaking. Right everybody, we have got a few questions, but before we get into the questions, there's just a couple of points I'd like to add from a practical point of view really, and down to some experience that we've had in my organisation the last few weeks. Always when you're doing the consultation with the workforce, you need to bear in mind that the workforce is getting older, and as the workforce gets older, with it come the issues that you've got to consider around people that are getting deteriorating through the sort of aging process, and also make sure that you've not got too many people on restricted duties in the same area. We've sort of fallen foul of that just lately, and that's resulted in somebody suffering an injury. It is a joint area though, of course, as is any occupational health topic really, so it's vital that you engage with HR, health safety, and then the relevant operations people on the relevant subjects, topics, so we're all part of the solution. And further to this event today, if those of you that have not already looked at the agenda, well, you'll be getting the agenda out for the IOSH Food Drink Conference in October. We've got some really excellent speakers and some case studies from other organisations that will develop the topic in general of occupational health, and then specifically a speaker who's going to talk very knowledgeably about how to manage sort of people through the rehabilitation process to get them back to being useful contributors in the workplace. The one question I'm going to start with though is not in relation to the MSDs, Chris, and it's a question around stress, which is obviously an occupational health issue. Have you dealt with any cases on occupational stress through the courts in the past?
Never in the past going as far as a prosecution. What I do know is that there was a string of improvement notices served, primarily on public sector bodies, around the time that the stress management guidelines came out. So I think that is potentially not as high risk across the board, although I do understand for particular industries that's an issue. So I'd be surprised if there were any greater sanction than a notice, but I stand to be corrected if anybody knows different.
And my advice along the same question would be to actually use the resource that's available through the HSE website on assessing stress and the five tests of stress and the management process. Get it in part of your occupational health risk matrix for relevant people, and show that you're doing what is, as Chris termed earlier on, what is reasonably practicable, and it should stand you in good stead. We've got another question here. I've only just read it, but there's an organisation here that's got MAC assessments completed for tasks. How often would HSE want these reviewing? We're working on 2 years, though our processes haven't changed. Would this be okay?
This is a great opportunity for a lawyer's answer, and the answer is it depends. There's no hard and fast rule on that, but you know when it's out of date and you know when it needed to be updated. I think as a general rule, with all of these changes coming in now, if it's 2 years on, at least have a quick look to see whether any of these new developments could be factored in. If the answer is that they're not relevant or they're not necessary, then fair enough. You end up, I'm afraid, being almost at the point where the process of having looked at it is potentially as important as what you find. So 2 years, not necessarily a problem. I would certainly argue it if anybody criticised that. If it gets beyond 3, again, no rule on that point, but there's always the issue of changes in the workplace, personnel, etc. So 3 years is a rule of thumb. There's no hard and fast law on that.
Got another question that's it's about systematic listening to workers during the assessment, and And rather than Chris getting involved in that answer, I think from a practical point of view, when you're carrying out your risk assessments, obviously it is good practice to actually have your safety champions involved to engage with the workforce, so you can actually understand it from their perspective. And if there are some more serious issues that people need referral to Occ Health for some help and advice around a particular problem, then refer them to an occupational health specialist and maybe a physiotherapist for some help. There are body mapping tools and other such things available, but as a general rule, for the kind of manual handling and sort of ergonomic repetitive strain issues that you'd come across in the food industry, I don't think you would need to spend a great deal of time and effort using those specialist tools when the practical tools are available through the HSE website.
Any other questions, then the details are there. If I can't answer them, then I'll certainly try and find someone who can. I hope that's helpful. I hope you enjoy the rest of the afternoon. Thanks for listening.
Okay, everyone. Well, thank you very much to Chris and Paul for coming in and delivering that. I hope you all found it really useful. Chris mentioned earlier, obviously, that we have recorded this session, and a copy of the presentation will also be made available to you shortly. Hopefully, I'll be able to get those out later on this afternoon, if not at some point tomorrow. So I will be in touch. What we will do is I'm going to leave I'm going to mute the microphones, but I will leave the chat open up for another minute, just in case you've got any last minute burning questions. And then after that, I shall close the chat, and you'll receive the holding page. So thank you all for attending, and hope to see you soon.